Good evening. Good evening, and a very warm welcome to all our expert panelists and the participants who have taken out time from their busy schedule to attend this fourth webinar session on this Secondary Standard Week being celebrated by the ICSI from 18th of April to 24 on the theme Decoding the Secondary Standards and Guidance Note issued by the ICSI. Today we are going to decode the aspects covered on the guidance note on the independent directors. Friends, we have received overwhelming response from the professionals for this webinar series, and with the greatest being the figure of approximately 8,000 viewers in the webinar of SS1 and SS2. My sincere thanks and kudos to the President ICSI for making out this unique initiative, and to our senior most member into the council, Mr. B. Narasimhan, who is the chairman for this Secondary Standard Committee. On the topic today for this session, I wish to share the brief background on why the Secondary Standard Note on the independent directors is issued by the ICSI. Friends, we all know that the primary task of independent director is to ensure board independence, protect the company from any opportunities, indiscretion that could committed by the promoters and the management, and the promoting investors protection through the good corporate governance, integrity, and accountability. In this backdrop, the ICSI has introduced a comprehensive guidance note on the independent directors, which besides covering the issues and challenges and also includes statutory and regulatory provisions, code of conduct, and compliances pertaining to the independent directors. The board plays a key role in providing directions to the management in terms of the strategic and also ensuring the companies operate in the best interest of the stakeholders as well as the shareholders. The board independence is seen as a cornerstone of accountability, and the presence of independent directors is a boardroom is an important vertical of the corporate governance. The dramatic changes in the regulatory environment in India on the corporate governance with the ever-changing and dynamic SEBI LODR regulations has enhanced the role of the independent directors in the corporate governance. Friends, the guidance note on the independent directors covers many issues covering company secretary professionals. This guidance note answers many questions on the appointment, rights, duties, liabilities, etc., etc. Let me give you all a flavor on some of the amazing things which you will find inside these guidance notes only. As you all are aware that a non-executive director is liable not only in respect of the acts and omissions and commissions by the company which has occurred with his knowledge attributes through the board process, and with this consent and covenants, and where he has not acted diligently. These terms have been researched and interpreted into the guidance note. The guidance note is very nicely summed up with the law covering the business judgment rule in addition to the case laws and research across multiple countries, including the United States, Canada, UK, that is England and Wales, and Australia. The guidance note also covers many issues which you will not find easily in any book or publication. Few examples like what is the duty of care, what is the fiduciary duty, what it takes to act in good faith, what is the prudent person role, and what is the acid test for being reasonable. The guidance note being provided to be an immense benefit not only to CS professionals but also to the companies as well as the directors in benchmarking the governance practices into the company. In today's session, we are going to deliberate upon this very important topic, and before we proceed, it's my pleasure to introduce my expert panelists for this session. The first panelist is Mr. Manikanta AGS. Welcome, Manikanta.
Thank you.
Manikanta is Company Secretary of Infosys Limited. He has more than 17 years of experience in the areas of corporate governance, secretarial compliances, finance, treasury, and among other matters. He is member of FICCI Corporate Law Governance Committee and a member of expert group on Secretarial Standard of ICSI. We welcome you, Mani.
Thank you, Praveen.
My second speaker for today's session is Mr. Ramaswamy Kalidas, the practicing company secretary from Mumbai. He is fellow member of the Institute of Company Secretaries of India, MBA in Finance from Jadavpur University, Kolkata. He has more than 4 decades of experience in the industry since 1978. He has worked with the Ambuja Cement and Reliance Power Limited and ACCs Limited in the history. Currently, he is a practicing company secretary. He was visiting faculty in XLRI, Jamshedpur, and authored more than 100 articles on related topics of corporate laws and SEBI regulations into various publications and bulletins. He is member of the expert group of the Secretarial Standards and earlier served as a member of the Secretarial Standard Board of ICSI. He is specialist editor of A. Ramaiah on Company Law, 19th edition 2020, and several other publications on the corporate laws. We welcome you, Khalida, sir. My third speaker for today's webinar is Mr. S. Sudhakar. S. Sudhakar is fellow member of the ICAI CA Institute and the ICSI and qualified secretary of ICSA UK and a law graduate from Mumbai University with over 3.5 decades of wide spectrum experience in the legal, secretarial, finance and accounting fields. Since 2005, he is working with the Reliance Industries Limited and has earlier worked for around 15 years with Berger Paints. Sudhakar is a member of the Secretarial Standard Committee of ICSI and Vice Chairman of Expert Group of Secretarial Standard of ICSI for the year 21-22. Earlier, he has served as a member of the Secretarial Standard Board from 2016 to 20 and as the Vice Chairman of Secretarial Standard Board in the year 2020. Approximately 750 seminar workshops has been conducted and he has been regularly addressing to the members, students into SNTM and MSOP of ICSI for past 15 years. We welcome you, Sudhakar, sir.
Thank you.
Friends, we will start with our technical part of the session, and we do have the immense and speakers and galaxy of speakers there. So we'll start with their own initial address from the topics, and thereafter we'll go with the question answers. Initially, I invite Mr. Manikanta ji kindly deliver your session, and then we'll go ahead for the next speaker. Thank you. Over to Manikanta.
Thank you, Praveen. Are you able to hear me?
Yes, please go ahead.
Yes.
Okay. Thank you, Praveen. It's always a pleasure to be part of the ICSI, and it's always a pleasure to be part of this esteemed panel. So thanks for inviting me for this session. What I will do is in the next 20 to 25 minutes, I'll try to give an overview of what is the guidance note. What does it speaks about the foreign independent directors? How does it cover? I will give some highlights of the guidance note itself. And I'll also try and summarize some of the expectations which are being seen from the independent directors, practicing professionals in employment, and etc. Right, and also I will provide some illustrations which has been described in the guidance note itself. I will try and share my presentation. Kindly let me know if you are able to see.
Do it again. It is not there. Yeah.
I'm going to see
there. Yes.
Okay. Very nice. Yeah, I think Mr. Praveen actually alluded to what is the requirement and why there is a guidance note on the independent directors. But I just wanted to give you a context that the guidance note is on the independent directors is actually available from October 2020. And this is a revised edition. The current format which you see is actually a revised edition from January 2022. The point what I want to make here is this is not a static document. This document is a living, breathing document. It responds to the requirements of law. Whenever there is a change in the law, it actually addresses it and incorporates. And if there is a major development, either economic or any other thing, it actually tries to address. Right? So if you see the expert group on secretarial standards, these are the people who are actually best in the country. Some of the best brains work on this topic. They actually crowdsource the problems from various areas, try to deliberate it and provide guidance. And also we have a secretarial standards committee which actually recognizes this secretarial standard expert group's work and have a governance mechanism to see whether it addresses the views of the ICSI or not. So therefore, it is a very robust process of making the guidance note. So it actually gives you a very important document. It is not only a compendium of the laws, but it's much more than that. There is a lot of research which has gone behind when the guidance note is prepared. So as you can see, it is not only the reference which is articulated in the guidance note of only the Companies Act or the rules or the SEBI listing regulations. It actually has a lot of informal guidance which is provided by the SEBI informal guidance mechanism. The references to there were also provided in the guidance note. Likewise, there is a reference to the interpretive letters or even there are some case laws which have been referred, which is passed by either the whole-time members of SEBI or even from other courts. Also, it actually has a reference to the secretary standards itself, which is SS1 and SS2, and various other secretary standards. The best part is it also looks for the benchmarking of the practices which is in the country. So therefore, the best practices of in the different jurisdictions have also been incorporated into the guidance note. Now, I would like to give a highlights of what are the things which are covered in the secretarial in this guidance note. The first of all, if you see, it actually dwells upon the evolution of the concept of independent directors in India. Way back from 1996, the journey which has happened, the very concept which has evolved as an independent directors in India have been beautifully articulated, and the reasoning of why there is a need for independent director has been clearly given out there. And if you see some of the unique challenges which is faced in India, it's a very unique challenge for us where the businesses are actually promoted by promoter groups. And therefore, this institution of independent directors is extremely, extremely important for a country like us. So therefore, some of the challenges which is faced by both corporate India and also the challenges we don't have the enough number of independent directors. And actually, the requirement, the qualification of an independent director also becomes a very important element before we onboard anybody as a part of the board. So these are some of the minute things which has been captured in the guidance note. Coming to the appointment of independent directors, this is a big topic by itself, right? So the way how the NRC sources the independent directors, how they look at it, they have to look at the skill metrics of the existing board, where they are finding the gaps in their skill set. Probably they have to look at the independent directors, search there, and then appoint. So there is a process of how the appointment of independent directors has to be done. I will try and cover as much as possible as we go along. And also, it speaks about the roles, duties, and liabilities of independent directors. Most of them may be referred to the Companies Act and listing regulations, but more importantly, if you see the concepts which has been listed there, like the instance of due and reasonable care, of how the independent director has to take care of the affairs of the company when he is approaching a particular transaction or particular problem, how does he has to take care of as though it is his own, and how he has to exercise his proprietary duty has been clearly articulated there. And it also speaks about what are the circumstances or how you have to avoid the conflict of interest if there is a particular transaction being discussed or being proposed at the board. Right. Also, it speaks about the undue gain or advantage, because independent director is at the helm of the affairs. So he should not be taking the undue advantage of the situation. So that's another duty which has been casted. It's though you don't see much reference in the act and the rules straightforward, but there is a good explanation which is provided in the guidance note. I think Praveen also mentioned about this business judgment rule and the protection for actions taken by directors in good faith, right? So this is something which is a reference which has been provided after a much of deliberation, which actually in some cases the independent directors can also look at it in case how do they protect themselves. If there is a business judgment which they have applied after ascertaining the facts and circumstances which they have in place, then what are the protections which is available by the regulations, and how can they protect themselves is something which has been clearly articulated. The next point is about the strategies for engagement with the management, right? So these are some of the practical scenarios where you may not find in any textbook or in any rules or regulations. Now, how do you engage with the management is something which has to be strategized right from the time when the independent directors onboards, right from the familiarization program to the training program and the board meetings, which happens on a quarterly or more frequent basis, is an opportunity to meet with the management. So therefore, you have to have a clear strategy of how you will engage with the management so that you can be more productive from an independent director standpoint. So some of the strategy which which companies have or the independent directors have approached is right from setting of the meeting of an agenda for the meeting itself. They try to engage with the management and also provide their inputs, whether to come out with an agenda which has to be deliberated in a manner which is productive and to the point. Therefore, the deliberation is to see whether something can be brought up which is not there as a regular item in the agenda. So some of the good practices, what they do is even before the meeting has been scheduled, there will be a topics of which can be debated or which can be put as part of the agenda. These are and the independent directors sometimes actually go out of the way and try to meet the management to understand the depth of the agenda notes which are provided. So I think there is a good explanation and a good practical approach which has been provided in the guidance note. The next point or the topic which I want to touch about is the proxy advisory firms, right? So increasingly from the last decade or maybe less than a decade, the prominence of proxy advisory firms have been at the center stage. Now, though their recommendations are not legally binding or it doesn't have a legal supporting, but they have a very influential capacity on the voting pattern itself. Now, most of the financial institutions, mutual funds, are the subscribers to these proxy advisory firms. And most of them actually rely on their advice and vote accordingly of any resolutions which is proposed for the shareholders. Now, some of the interesting facts which has to be taken note by the professionals and also by the independent directors is the proxy advisory firms, how they look at each specific matter. Like for instance, they look at the attendance details, right? So how the director has attended the board meetings. When these attendance details will be actually looked into when the proposal is placed for a reappointment of a director. Though the law gives you the minimum threshold, but the proxy advisory firms have a higher threshold. They actually ask if the director has attended more than 75% of the board meetings. So that is one criteria which they are looking at it. And also, interestingly, they are seeing the overboarding concept, right? If the directors have many positions in different companies or the boards, then this is something which has to be watched out for. Though the regulations has a limitation of higher number, the proxy advisory firms actually has a very low number. In fact, it says that if you can't, they give a negative voting if an individual is having a board positions of more than 6 companies, and if they have more occupying the more committee positions, they actually give a negative recommendation. Likewise, they also see for a long-term association of an individual with the company. Though the Act says that it can be 2 terms of 5 years each, but it doesn't. There is a cooling off period, or there is a grandfathering for the period which has been elapsed before the Companies Act 2013 came into existence, right? But the proxy advisory firms have a higher lens of looking at this. They say that if an individual has been associated with, irrespective of whether the law was there or not, the individual has actually lost the independence. Therefore, he should not be proposed for an independent director position is their viewpoint. Of course, the diversity is a center piece which has been deliberated by all the boards today. So proxy advisory firms also look at this dimension, whether your board is actually diverse enough. It's not only a gender diversity, it is a mix of the skill diversity, ethnicity, culture diversity, etc. So therefore, they look at from this dimension, and if they are not satisfied, or if there is too much of weightage on particular issue, they end up giving a negative recommendation for the NRC members, Nomination Remuneration Committee members. We have seen a pattern where some of the proxy advisory firms have actually given a negative recommendation of the audit committee members if they come up for a re-election, in case if there is an excessive non-audit fees which is paid to an auditor. So that's an interesting point which has been covered in the guidance note also. As I was saying, the guidance note actually caters to all the stakeholders, right from independent directors to the professionals in employment or in practice. It actually caters to the students, practitioners, academicians, etc. Now, what I will try and see in this slide is to see what is the perspective from the independent directors. What can they take out from this guidance note, right? So if you see from their perspective, there is a lot of reference for what needs to be, what is expected out of them from each particular category of the stakeholder, right from investors, regulators, promoters, banks, etc., has a different kind of an expectation from an independent director. So when an independent director is sitting on a board, he is actually playing a role of a fiduciary nature, and he is supposed to look after the expectations of each of the stakeholder before he decides or provides his guidance on any of the topic. Independent directors can actually look into the guidance note to satisfy themselves and to understand the legal requirements. So this is one place where actually there is a it is a list. This is one place where actually all the requirements as per the Companies Act or the listing regulations or any circulars has been put together in one place, so that it gives you a synopsis of what actually has to be done. And it actually gives you the different kinds of instances of how it has to be handled. If there is a disqualification, if there is a material subsidiary of a listed entity, then whether is there a requirement of a common independent director to be on the board or not, is something which has been deliberated. The guidance note also speaks about the directors and officers insurance, which has to be commensurate with the size and business of the entity. There is a lot of information on the remuneration which will be paid to the independent directors, how it has to be calculated, and what are the fees which can be provided, and what circumstances it can be given, whether it can be given to the board committees, whether it can be given to the general meetings, whether it can be given to the independent directors meeting itself or not. So there is a practical approach, and the questions, as I was saying, these are the questions which have been crowdsourced from various practical scenarios, and there is a guidance on each particular topic. If you look at from a professional's point of view, what the guidance note caters is actually the overlap of what I covered in the previous slide and throughout the presentation. And additionally, it actually gives you the guidance of how an appointment or a reappointment can be done. It gives you the each particular step of what needs to be done. Like for example, in NRC, they have to look out for the skill sets or the skill metrics before even an appointment is made. Then after that, when it goes to the board, what role it has to play, and how does it take the recommendations of the NRC is something which they will rely on, and then make a proposal to the shareholders. And there are many timelines which have been given of when the shareholders' approval has to be taken. Like for instance, in the recent January 2022 circular, or the amendment by listing regulations actually requires the approval by the shareholders within the 3 months from the date of the appointment itself. Yeah, and one more important point is about the disclosure. What needs to be provided as part of a disclosure when there is a appointment or a reappointment of an independent director has been clearly provided. It also draws to the reference of Regulation 30 of the listing regulations, and it clearly describes of what all needs to be looked at it by the company before they make the proposal for the shareholders' approval. Also, there are many model policies, specimen or specimen of the forms which have been given, and there are statutory registers format which has been given, which will, I am sure it will be helpful for the professionals in both in employment and practice. So there is a description of tenure, of how many terms an independent director can be there, whether he can be liable to retire by rotation or not. Of course, the independent directors are out of the retirement by rotation. Tenure we spoke about. Tenure can be 5 years or 1 term, maximum of 5 years. It can be 2 terms. And how the agenda has to be prepared for each specific meeting, right? Whether it is the board meeting or a committee meeting, what all needs to be provided there. And the minutes, how it has to be drafted. It also gives you a reference back to your Secretarial Standard 1. which speaks about the recording of the minutes in when the board meeting happens. And more importantly, if there is a point which has to be noted by an independent director, or if there is a dissent which is coming from an independent director, it has to be recorded in the minutes. And also there is a comparative table of the Companies Act and listing regulations. What exactly is required from the Companies Act, what is required from the listing regulations have been beautifully articulated in the guidance note. So which can be one place to look at for all the professionals. I will try and cover a few of the illustrations provided in the guidance note. So this is the case which had come to check on the remuneration of non-executive directors, including independent directors, requires an approval of an audit committee. Now, if you see the requirement of the Companies Act, it says the payment of remuneration to non-executive will not be considered as a related party transaction. A similar view is also given under the guidance note, which is pertaining to the related party transaction. Therefore, it can be considered that it is not mandatory to have the prior approval of the audit committee. But I think it's as a good practice, many companies do take the approval of the audit committee when there is a proposal for non-executive directors remuneration. Moving on, this is an example to speak about whether there is a requirement to follow the SS1 when the meeting of independent directors is convened. Now, the real guidance is a meeting of independent directors is not considered as a meeting of the board or a committee because this is not a committee of the board itself. Independent directors is a different class of directors itself. Therefore, it need not be recorded. The proceedings of the meeting may not be recorded, and the requirements of SS1, which gives you the advance notice, the way it has to be maintained, the minutes, the way the meeting has to be conducted, will not apply. Another example which came when we were drafting the guidance note is about whether the summary note or the minutes of the meeting of independent directors should be placed before the board of directors or not. So there is no real guidance from the Companies Act or the listing regulations, but I think as a good practice, summary of the outcome of the meeting of the independent directors meeting should be briefed to the board chairman, and as a good practice, it also has to be debriefed in the board during the next session. So those were some of the topics which I wanted to touch upon, and I'll be happy to take any questions. Thank you. Praveen, back to you.
Thank you, Manikanta. A wonderful detailed deliberations you have given. Excellent, and really appreciate. We'll go with the next speaker, Mr. Ramaswamy Kalidas here. Would request Kalidas sir kindly enlighten with your knowledge base and data information which you want to share. Over to you, sir.
Thank you. Good evening, everyone. It's always a pleasure to articulate on a intricate issue such as independent directors in the midst of the fraternity, and this is an exercise which is of an ongoing nature. This particular week is dedicated to coverage on the secretarial standards and the guidance note, and therefore as part of this continuum we are today looking at the role of the independent directors. Mani did a wonderful exposition of the independent director's guidance note. In fact, he drew the entire canvas of the spectrum of activities that have been encapsulated in this guidance note, and I have very little to add by way of value where it comes to the articulation on the guidance note, as it were. But except to say that I have a different take on, I shall look at some, I shall throw for discussion certain issues which engage the minds of professionals where it comes to appointment of independent directors, their roles, etc. And but then, as by way of a historical perspective, let me add that the independent director as a genre of directors made an entry into the Indian corporate scenario way back in 2000 when we had the Clause 49 of the listing agreement, which was adopted by SEBI on the back of the recommendations made by the Kumaramangalam committee report. And of course, initially the role of the independent director was very, very unclear because there were very little documentary evidence available with regard to how independent directors can demonstrate their role in the board. And, they were in the initial start of their, in the nascent growth of this body of individuals, they were analogous to wallpaper. And companies took pride in engaging retired civil servants of distinguished background, army generals, etc. And for them also, it was some kind of a superannuation with certain perks. So therefore, the role of the independent director was largely undefined until, there were certain further refinements in the concept. In fact, the Naresh Chandra Committee threw some further perspectives with regard to what qualifies for independence. But having said that, notwithstanding all the condiments that are available under Section 149(6), as also in Regulation 16, where it comes to defining an independent director, the fact of the matter is that at the end of the day, independence is a state of the mind. Now, you may be qualified in terms of acquitting yourself in all the attributes. You could be ticking the box everywhere where it comes to 149(6) or Regulation 16. But the fact of the matter is that independence has to be demonstrated by the independent director fearlessly and without fear or favor. In fact, he should not end up as a golf crony of the promoter, because the one major issue that an independent director in India has to confront, as opposed to developed markets in the world, is the fact that in India, given the fact that capital is a prerogative of only a few, so necessarily most of the companies in this country are promoter driven, and the independent director has a role to play by walking the talk, as it were. He has to be somebody like a juggler in a circus, or he has to walk the tightrope and ensure that there is a balance of interest and ensure that there is no conflict of interest as between the company, the minority, and the promoters. So that's a very arduous role that the independent director has to play. But having said that, I would like to add one small perspective where it comes to who's an independent director under present law. The paradox is that, if you look at clause 49, a nominee director was considered as an independent director, whereas the present law does not consider a nominee as an independent director, given the fact that a nominee is supposed to be catering to the interest of a particular constituency. The particular constituency being either the lending institution or the investing institution. Now, if you say that protecting a particular constituency results in laws of independence, by the same yardstick, there is an inherent contradiction that is existing in the law where it comes to Section 151. 151 speaks about somebody being appointed as an independent director to protect the interests of the small shareholders, and there is a process by which the small shareholders can appoint an independent director. Admittedly, the tenure of an independent director appointed in this process under 151 is only 3 years as opposed to 5 years for a term. But sadly, shareholder activism has not matured to the level that is expected of in India so far, and therefore very few companies or very few shareholders have demonstrated their strength by seeking to appoint an independent director under 151. So if somebody who is representing a small shareholder is an independent director, by the same token, I do not see why somebody who is protecting a larger constituency, after all, the stake of the public money is much more in the context of a listed company where there's a lending institution. So I do not know why a nominee cannot be an independent director. But having said that, this is a contradiction and a paradox which we perhaps have to live with, right? Where it comes to shareholder activism under 151, I can only recall one instance of shareholders attempting to appoint an independent director through 151, but that was scuttled down for some technical reason. If I recall correctly, it was a Baroda-based company into chemicals, which said that the person sought to be nominated was never a small shareholder, which gives rise to a larger question whether under section 151, if the requisite number of shareholders have made a requisition for an appointment, whether the board has a right to reject the candidature. Now, with this perspective, with this background, let me throw for discussion and some food for thought where it comes to some facets of independence. Now, SEBI, in fact, where it comes to independent directors, I think the positive game changer was the 2013 Act. It provided for the first time that the requirement of an independent director, not only for listed companies, but also for unlisted public companies, satisfying certain financial thresholds. Now, having said that, SEBI has been also doing its role where it comes to enhancing the role that the independent directors have to play. And let me say that the SEBI and MCA are working at different channels, and as they say, the twain shall never meet. In fact, every day the areas of divergence as between the MCA and SEBI is widening, and ideally it would have been an ideal situation if there was a congruence where it comes to conceptual reduction in the conceptual diversity. But sadly, that's an utopian idea, which we have to therefore live with the fact that SEBI, well, I may be wrong in using the word, it's either my way or the highway. Same goes for MCA also. But where it comes to the independent directors, there are certain developments in the law which I feel very strongly about. The first is this requirement of SEBI effective from January 1, 2022. They have said that all related party transactions will have to be approved by independent directors who are only part of the audit committee. As you are aware, all independent directors need not be part of the audit committee, and those that are familiar with accounting, etc., are generally the ones who are in the audit committee. So what is it suggesting? I personally feel that this is this is not a law which is justified for two reasons. One is that by making the independent director responsible for clearing a related party transaction, you are actually willy-nilly asking him to play an executive role. As you are aware, by definition, an independent director is a non-executive director who visits the boardroom in an interval of 3 months. How is he going to be commercially literate? How is he going to be commercially proficient? And whether he has the bandwidth to clear a transaction which is purely commercial. And perhaps there are, I'll give you an example from my own experience in ACC. We had certain sourcing of raw materials for the Indian subsidiaries of Wholesome, which was a 91-nation conglomerate, and they would source worldwide things like, pet coke, etc., for all the companies under the banner. Now, the commercial considerations are so intricate that it is well beyond the reach of an independent director. He hasn't also the time to articulate on these issues. So firstly, you are making him play a role which is an executive role, which is completely an antithesis where it comes to his role. Second is that given the fact that some directors who are independent are not part of the committee, you are willy-nilly creating a wedge between the body of independent directors, which is not desirable. And thirdly, whether by giving this executive responsibility, are the independent directors are generally very, very wary about taking executive decisions. So perhaps the chances are that they might fight shy of taking decisions on commercial considerations for related party transactions. So it could well be the case of missing the wood for the trees. So I personally feel that this is not a justified law. Of course, this, the disclaimer I always offer when I speak in a fora such as this is that these are my personal views. And of course, I do not mean to belittle in any way the administrator or the regulators. So this is my personal view, and I think this is not a justified law. Second point which I wish to wish all of you to ponder over is that Manikandan did mention about whether a meeting of the independent directors has to be considered as a meeting of the committee of directors. And in fact, our secretarial standard 1 says that it is not a meeting of the committee. But let me add one new perspective which has come up in this area. That is you probably are aware that the National Stock Exchange has introduced a concept of listing of prime securities, where they are seeking to enhance corporate governance beyond the frontiers of law. And one important decision, at least it's a, of course, this will not have any legal stature, given the fact that adherence, embracing this code is entirely voluntary. But what they have said is that a meeting of the independent directors has to be actually considered as a meeting of the committee. Because what is a committee? At the end of the law doesn't have a definition for a committee, but you realize that when directors belonging to a particular species are meeting, they are all independent directors, and therefore a committee is actually a subset of the board. And to my mind, there's nothing wrong in calling this a meeting of the this as a committee of independent directors. And given the fact that there is a set agenda which they have to, I admit that there is the agenda which is to be transacted is highly sensitive, in the sense that you have to provide also feedback on whether the chairman is allowing a free interplay of ideas and things like that. But to my mind, it's always better to accept and criticism on face value rather than ignore something which is written on the wall. Now, if the independent directors feel that the chairman is not contributing to a free interplay of ideas, then by all means they have a right to express their views. And to my mind, there is nothing wrong in sharing the outcome of the proceedings of the meeting of the independent directors. And in fact, in ACC, we always used to do so, and the company secretary was allowed to be part of the meeting. And what used to go to the chairman was indeed a completely unedited version of what transpired at the meeting. So to my mind, there's a strong case for considering this as a meeting of the committee of directors. And perhaps we may have to revisit the standard because, after all, the benchmarks for corporate governance are constantly rising. And one way by which the benchmark can be enhanced is by sharing what transpired in a meeting of the independent directors. Then again, this is my personal view. And, I'm not trying to impose my views. And my view is also fortified by what has transpired in the National Stock Exchange by way of this requirement of the prime list of securities, which is going to be a concept which will be voluntary from July 1. The next question is, now, whether an independent director can be appointed for a term less than 5 years at a time, and what are the consequences? Now, the law says that an independent director can be appointed for a term of up to 5 years. So therefore, this suggests that if you want to reduce the time frame for the appointment, you can make it 2 years. You have the flexibility to make it 3 years. You have the flexibility to make it 4 years. But if you are reappointing him, then you cannot, there is no carryover of this unexpired period, meaning that if you want to appoint the independent director for the second term, suppose you have appointed him for only 3 years, you can't appoint him for a period of 7 years this next time around. And as Mani mentioned, the proxy advisory does not consider a person as independent who has been with the company associated as an independent director prior to the introduction of the Act of 2013. But I think this grandfathering provision will eventually by the flux of time, make its exit in 2024. So then we will have a level playing ground in that nobody will be there who shall have a term of more than 10 years. And of course, that will be followed by a cool-off period of 3 years. Now, the other thing is that I think the next question will answer now, whether an independent director can be appointed by the board by passing a circular resolution. Now, the answer to this is technically it is yes, because there is nothing which, the board can appoint under Section 152 situations where you want to appoint somebody as an additional director, as somebody in a casual vacancy, or somebody as an alternate. Of course, an independent director cannot be an alternate for another. But where it comes to an additional director, the board can appoint somebody as an additional director in the capacity of an independent director. And this can be done by circulation, because 161 does not prevent that process. But having said that, like Mani mentioned about the role, there is a role of the nomination committee in that the committee has to ponder over the skill set of the person that is sought to be appointed, and whether the skill sets that are being contemplated are compatible with the requirements of the company. So perhaps there would be a need for the nomination committee to articulate on the suitability and maybe even conduct an interview of the candidate. And based on that, the board has the recommendations of the nomination committee. The board has to take a decision. So although it is theoretically possible to appoint an independent director through the process of a circular resolution, I would not advocate it, given the fact that there are so many areas to be considered, and it would be appropriate if it is done. Not only the nomination committee should meet physically, well, not physically in these days of COVID, at least there should be a virtual meeting followed by a meeting of the board before you decide on appointing a nomination, an independent director. Next. Yeah, whether the next interesting question is that this I have been asked a lot of times by a lot of people, whether you can pay fees to the independent directors for attending meetings of their independent directors meeting, and even in fact for the general meetings. If you look at section 197.5, there is an enabling provision in 197.5, which says that the board can pay fees to the directors for attending meetings, as also for any other purpose which the board considers appropriate. Of course, this subsection has to be read with Rule 4. Rule 4 is slightly diluting the position, because it says that the fees that are to be paid for the directors for attending meetings of the board and committees constituted is restricted to rupees 1 lakh per meeting. Now, that would necessarily lead to a conclusion that the intention of the law is to only restrict the payment to only a meeting of the the board and the committees constituted by it. But having said that, it is a settled principle of law that rules are supposed to be part of the Act only when they are consistent with the provisions of the Act. 197.5 has an enabling provision by which fees can be paid for purposes other than for meetings. So the rule cannot therefore scuttle 197.5. And to my mind, notwithstanding that the Rule 4 speaks about payment for meetings, to my mind, there is nothing wrong in paying independent directors sitting fees for attending the meeting of the independent directors, and also for general meetings. After all, he's actually investing his time, and therefore, why should he not be paid remuneration? I cannot for the life of me understand. And of course, this should not mean that the more the merrier, and the board suggests that you have 5-6 meetings of independent directors. That is not the idea. But if there is a meeting of the independent directors, logically, to my mind, there is nothing which stops. In fact, there are certain companies, including ACC, where we do not pay sitting fees for meetings of the CSR committee. Now, that's a conscious decision of the board, because they consider that receiving sitting fees while articulating on the board's policy on CSR is actually an antithesis. So therefore, companies, they never paid sitting fees for a CSR committee, which is a committee constituted under law. Now, that being so, why is it not justified when you want to pay sitting fees to the independent directors for attending their meetings or the general meeting? The last point that I wish to share my thoughts on, this is a limitation in the law which probably needs to be addressed down the line by MCA. In fact, I have written about it in several fora, in articles, in my book also. You see, if you look at Section 16, today, if you want to remove an independent director for a listed company, you need to do through a process of a special resolution, right? 169 says that if you want to remove a director or remove an auditor, then you will have to, do so by an ordinary resolution. And there is a requirement of a special notice from the shareholders. Assuming that the shareholders have provided the requirement of a special notice, in that case, the moment the shareholders of the requisite number have sought the removal, then the company has to forthwith provide this notice to the person who is sought to be removed. And the independent director, or for that matter, any director or the auditor, has the law. In fact, the present law under 169 is much more liberal where it comes to the coming to the rescue of the person sought to be removed. The present law speaks about the incumbent director or the incumbent auditor being given a reasonable opportunity of being heard. Whereas under the old act, under section 284, the requirement was that he had only a right to be heard. Now, the point I'm making is this: the moment there is a requisition which has been received by the company will forthwith send, and the law says that within 14 days from the date of the meeting, the company can act on a requisition for a removal of a director, right? And if the notice goes, then the director has two options. The director or the auditor has two options. Either he makes a written representation. If he makes it in time, then possibly the company has the opportunity of circulating that submission to the shareholders. Alternatively, if he wants to, if there is he's foul-mouthed and he wants to wash dirty linen in public, he might want to make a verbal representation on the floor of the meeting. Now, how does he do so in the context of a listed company where you have the requirement of e-voting, and the e-voting paraphernalia closes before the beginning of the board AGM? So it ends, the e-voting process ends one day before the meeting is to start. So how does he make a representation? So I think, to my mind, the law is very unfairly loaded against the director who is sought to be removed. And in fact, that is why I like very much the recommendation which was made by the Kotak Committee on amendments to LODR. The Kotak Committee had said that the e-voting process should conclude only on the midnight of the general meeting, because that gives the opportunity to the shareholders who are present at the meeting, or probably now we are going to have a scenario of a hybrid meeting. You may be present virtually. You are able to gauge the sentiment of the shareholders. You are able to gauge the general sentiment of the shareholders when it comes to management. So the Kotak Committee had recommended that the e-voting process should conclude only after the conclusion of the annual general meeting. And to my mind, there is a strong case for amending this requirement, given the fact that the law is unfairly loaded against the independent director who is seeking to make a representation on the floor of the meeting, right? So these are the points which I thought I will share with you. And if there are any questions, and I think I've stayed within the time allotted to me, thank you very much for letting me share my thoughts. Over to Praveen.
Thank you so much, Kalidas-ji. You have covered up only 6 questions, but in 6 questions you have covered up most part of this presentation. And in Hindi it generally says, "Kagar mein sagar aapne bhar liya hai." So that's a wonderful presentations and detailed introductions about the topics and the matters. We got this. My next speaker is Mr. S. Sudhakar from Reliance. Sudhakar ji has already got a lot of deliberations on the topic. Personally, we discussed, and then now lots of things has been covered by Mr. Mani and Kalidas also. And I had seen Mr. Sudhakar in working when I had shared the secular standard board for 2 years with him. So over to Kalidas, over to you, Sudhakar ji.
Thank you very much. Thank you very much, Praveen. I'm sure I'm audible.
Yes, please, go ahead.
Thank you. Thanks very much and good evening, participants and my co-panelists. When you are the last speaker, you have an advantage as well as a disadvantage. Advantage is that predecessors have already taken care of everything, so you can relax. You don't need to do much as such. But at the same point of time, when your photograph has been given on the brochure and you have been invited as a speaker, you have to speak something about. So I was virtual. I have to be attentive when both the other speakers are speaking, what they're leaving for me, so that I can take care of that. So apart from this thing, in fact, at the outset, let me thanks and express my sincere gratitude to ICSI for giving me liberally opportunities to share my thoughts with all the participants. And once again, my thanks to President ICSI and all the council members for taking this excellent initiative of Secretarial Standard Week. Because the number of participants, day by day, it is increasing. I have been told even today also it is 7,000 plus participants are there at the commencement of this webinar. I'm sure the number might have gone up. Question is not number, but question is the amount of interest what the people are taking in this. We are really delighted at the expert committee group. Coming back to the subject of independent directors, this concept is getting evolved over the last 2 decades. It was introduced in the early 2000s, that under the way of Clause 49. And that point of time and to date, if you see the journey of the independent director has completely changed. A lot of stringency has been brought in the definition as well as the expectations, accountabilities from the independent directors. In fact, I always advise the directors who are the aspiring directors when I go as a faculty to Institute of Directors. I tell them that don't take the directorship as a vocation. Those days are gone. In fact, in the good olden days, the people of eminence or the people who are celebrities, they used to take directorships as a vocation. They used to get the fringe benefits which the corporates used to offer to them. But the kind of arduous responsibilities which have been entrusted upon the directors in general and independent directors in particular, it is not a child's play. One has to to prepare himself or herself properly, get proper induction, get proper training, and have proper understanding of your role, what you are going to play before accepting the independent directorship. I remember almost 4 decades before when I joined for my chartered accountancy as an articleship. Before I was before I asked to go for an audit, my principal told me, you people are not supposed to see what you have been shown, and you are not supposed to hear what you have been told. I got completely baffled. What does it mean? Don't see what you have been shown and don't hear what you have been told. That means you have to do much beyond what is happening there. At the same point of time, he also told us that try to see with your ears and hear with your eyes. This is another big statement. So these things, an independent director too have to do it. He should not see what he has been shown only. He has to see much beyond that. He should not hear what he has been told. He has to try to hear much beyond that. If you want to really discharge your responsibilities the way it is expected, the independent directors need to pull themselves up. They should have sufficient time at their disposal. They should have sufficiently groomed up. Then only they have to accept this. Having said this, I have a small presentation also for whatever the things. Little bit of overlap may be there for the sake of continuity, but I will skip those slides. The rest of the things I will take care of. I'm sure you are able to see my presentation. Am I correct?
Go ahead.
Thank you. Let me put a disclaimer that whatever the views I'm expressing, these are my personal views. Nothing belongs to the organization in which I'm employed. At the same point of time, I am a member of SSC as well as expert committee, and these views are not of the SSC or expert committee views. As I was mentioning that the concept of independent directors is evolving over the 2 decades. The independent directors are primarily, they have to bring value to the board and provide right balance with their diverse and cross-functional professional skills and maturity. They have to facilitate the corporates to navigate through the growing complexities and the challenges, as well as ever-increasing compliance of laws. They are the real guardians, custodians, and gatekeepers of corporate governance. They have to protect the interest of not only of the shareholders, but also of various stakeholders of the company. One main question everyone grapples with these days is, what is independence and how independent the independent director is to be? Because as Mr. Kalidas has mentioned that independence is a state of mind. According to me, independence is a perception and it can't be defined or legislated. At the most, a framework can be prescribed. That is what exactly has been done by the Companies Act 2013 and Listing Regulations 2015. They prescribed a framework to determine that who is an independent director and what is independence. Now let us see that appointment of independent director, this is primarily I'm going to deal with because there are certain interpretational issues are involved with this. As provided under section 149(10), Mr. Kalidas has already mentioned about this thing that the independent director shall hold office for a term up to 5 consecutive years. Because of that, the first term can be 5 years or less than 5 years, but it will be counted as 1 term. Such independent directors are eligible for the appointment of a second term of 5 years on passing a special resolution by the company. These words are very, very important. On passing a special resolution by the company, the eligibility is there for the independent director for second term. This means it is a prerequisite that the independent director's appointment by way of a special resolution to be there before the second term starts. Then, of course, there is a cooling period of 3 years, and then only the independent director will be again eligible for appointment of again another 2 successive terms. And during this 3 cooling period, he should not be connected or associated with the company or its subsidiary associates, etc. The independent directors shall not retire by rotation. Hence, the board composition should be in such a way that 2/3 of the directors shall retire by rotation as provided under section 152. Several times this question comes to me that whether the independent directors are to be counted for the purpose of the size of the board. When we talk about 2/3 of the directors have to retire by rotation, who are liable to retire by rotation, out of which 1/3 have to retire every year. For example, if a company has 2 executive directors and 2 independent directors, and the executive director's appointment is in such a way they are not liable to retire by rotation, independent directors by law, they are not liable to retire by rotation. That means this board composition is not correct at all under 152. So the board has to induct some more directors who are to be liable to retire by rotation. NRC has a major role to play, and in the recent amendments which have come in the listing regulations, further responsibilities have been added on them. They shall evaluate the balance of skills, knowledge, and experience on the board. So they have to prepare a description of the role and capabilities required by the incumbent, and that person who matches those skill sets or the role and capabilities, etc., only is to be recommended to the board for appointment as an independent director. So the person recommended to the board shall have those capabilities identified. For the purpose of identifying suitable candidates, wherever it is so required, the NRC is within its rights to use the services of an outside agency also. Now, appointment for the first term, he is to be appointed as an additional director and who may be designated as an independent director. Because under 150 subsection 2 provides that the appointment of an independent director shall be approved by the company in general meeting. It is also provided under Schedule 4 also, and as provided under section 152 subsection 2. 161(1) provides that a board of directors can appoint a person as an additional director. So the holistic reading of the above, it does not imply that the prior approval of the shareholders are required for appointment of an independent director. Hence, it confers the power on the board to appoint the independent director for the first term as an additional director who may be designated as an independent director subject to the approval of the shareholders. In fact, as far as the second term is concerned, it is not so. As I have mentioned already, second term, he is eligible only on passing of a resolution, special resolution by the company. That's why there is a difference between the first term appointment and the second term appointment. Of course, with the first term, when you are appointing him as an additional director, though you are taking the approval of the shareholders in the subsequent general meeting, but the period of 5 years shall be counted from the effective date of appointment as approved by the board. Circular resolution, Mr. Kalidas has already mentioned about this. Now for the second term, as I told you that it is a prerequisite and the board has no power to appoint. Board can't appoint a director as an additional director designated an ID for a second term. Any reappointment should be treated as fresh appointment, and all the formalities as far as the consent, disclosures of interest, etc. are concerned, that is need to be obtained afresh. So what the outcome of this is that before the first term expired, he should be the approval of the shareholders should be taken that from the date on which his first term getting expired, he will be continuing as he is reappointed as an independent director for the second term of 5 years. That means this approval should be in place before the first term expires. Now, if there is a break, suppose for whatever the reasons it is, before the first term expired, the approval of the shareholders could not be obtained for the second term. What happens? Now, section 149(11) provides that no independent director shall hold office for more than 2 consecutive terms and shall be eligible for reappointment after the expiration of 3 years. Now, the word what it was used is, he is eligible for 2 terms of 5 years each, but these 2 terms should be consecutive terms. Though the Act has not defined consecutive as such, but the dictionary meaning means consecutive means it should be in successive. There cannot be a break in between. If there is a break in between, that means it is not consecutive and it is not in compliance with the law. Hence, before the expiry of the first term, the independent director need to be reappointed for the second term. Now, suppose a question may come that this first term expired and there is a gap. Can he be appointed? Answer is no. Can he be appointed, say, for example, after 3 months? Now, the second term, they cannot appoint him. So, can he be appointed and call it as a first term? Answer is no, because he has already served for the first term of 5 years. Such independent directors, in such case, has to necessarily go for the cooling period of 3 years. Then only he will become again eligible for appointment as independent director. This, all the participants must know the finer points of this. Very elaborately and comprehensively, this is explained in the guidance note, and ensure that the appointment for the second term is in place before the expiry of the first term. In case of listed companies, this is also again already Mani has explained this thing that, so I'm skipping that. This I have already told you. Now, can an independent director of the completion of which 2 terms or upon his resignation during which tenure be appointed as an executive director? Recently, there is an amendment which has come to the listing regulations, and regulation 2511 says that, which has come into force effective 1st January 2022, an independent director who resigns from a listed company, he shall be appointed as an executive or a full-time director only after a cooling period of 1 year. This effectively means that only this provision is applicable in case of resignation. Suppose if I am an independent director and I have completed my 2 terms of 5 years each, can I be appointed as an executive director from the next day onwards? Answer seems to be yes, because I have not resigned, I have completed my 2 terms, then only I am being appointed as an executive director. So now, however, upon the resignation as an ID, can that independent director continue as a non-executive, non-independent director? The answer to that is, when the shareholders have appointed that executive director, that director as an independent director for a period of 5 years. They have not appointed him as a simpliciter director only. So for the remaining period of that, he may be as a non-executive director, but according to me, again, shareholders' approval need to be obtained for such continuation. Now, resignation. In case an independent director resigns in between, that disclosure on resignation of independent director is to be given to the stock exchanges, and listed entities in their corporate governance report shall give detailed reasons for the resignation of the independent directors before the expiry of their tenure. Even independent director, while resigning, he cannot simply say due to personal reasons or due to other preoccupations, due to on health grounds and all those things. He has to specify clearly what is the reason for his resignation before his expiry of the tenure. And apart from that thing, he has also to give an affirmation that apart from the reasons, whatever he has stated, there is no other reason for his resignation. At the same point of time, while intimating the resignation to the stock exchanges, even the company has to give an affirmation that other than the reasons quoted by the independent director, there are no other reasons for his resignation. So this also, such in case of resignation, obviously we know that there is a casual vacancy, and such casual vacancy shall be filled up by the board of directors of the company within a period of 3 months. In fact, this particular provision also substantiates that the board has the power to appoint the independent director for the first term subject to the approval of shareholders. Effective January 1st, 2022, it is mandatory for the company, while intimating the resignation to the stock exchanges, they have to also submit the copy of the resignation letter what the company has received. And as I mentioned, that such intimation has to provide the detailed reasons. And along with the letter of resignation, the company should also provide the details of listed companies with which the outgoing independent director is associated, indicating the category of directorships and committee of memberships. An independent director can be removed by the shareholders by serving a special notice, and a special resolution is to be passed. Mr. Kalidas has mentioned, given his views about the opportunity of to be heard. But in case of listed companies, stock exchanges shall be intimated about the removal with the reasons and all those things. Thank you very much for your patient listening. Now we can discuss it further when we take effective question answers. Thanks very much.
Thank you, Sudhakar sir. You have covered the most of the part of the resignations of the independent directors, and lots of questions have also been covered into this. We are continuously receiving the questions and certain questions on the topic relating to this program. I'll take up the questions one by one, and then we'll try to have delivery. If one of the other speakers wanted to have some more additions to that, you may kindly let me know. My first question to is Kalidas sir, whether the spouse of secretarial auditor or statutory auditors of the company be appointed as independent director in the company. Sir, can you unmute?
To my mind, the answer is no, because of the fact that, in fact, there are SEBI advisories to the effect that even if the spouse is financially independent, the spouse is affected by the insider trading regulations where it comes to trading based on price-sensitive information. So that being so, given the fact that the secretarial auditor is supposed to be an independent person, obviously the spouse of that secretarial auditor cannot be an independent director. It's a paradoxical situation which the law cannot give rise to.
Would the situation be different if the person, the incumbent, is a friend of an director?
Well, the law is so far restricted only. You see, that way, if you extend the concept of independent directors in real terms, then you will find that most of the independent directors are friends of the promoters. So therefore, the law cannot, put a restriction on a friend of an independent director or for that matter, even a live-in relationship. So to my mind, there is no way that the law can stop the friend of an secretarial auditor being an independent director.
And the friend can be categorized in later good friend, just like friend.
Well, good friend, acquaintance. Of course, there's something about, I think there's something about a financial relationship, but that's a specific requirement under the insider trading regulations. So that apart, I don't think there's anything to stop a friend of a secretarial auditor being an independent director.
Okay. And something relating to this, can spouse of independent be appointed as an independent in the same company?
Of course not. I mean, the same logic applies where it comes to the secretarial auditor. So
Correct.
independence has to be demonstrated. Of course, admittedly, as Sudhakar said, it's a perception. But there are ways of demonstrating independence which are available within the law. And let us not abuse the law to allow the concept to be clouded by apparent contradictions.
Yes, Sudhakar.
Praveen, to add this section 149 subsection 6, which determines the qualifications to be an independent director, it clearly prohibits that relatives of directors cannot be qualified to be independent directors. At the same point of time, the relatives of auditors, secretarial auditor or cost auditor also, they are not to be eligible to be appointed as independent directors. There is a clear-cut prohibition is there in the section itself.
Correct. Sudhakar, this question is there, but I think you have already replied that the first term of the director without reappointment of second term. So that appointment has to be done before the first term ends actually.
Yeah.
Whether the independent directors proposed to be reappointed should provide a fresh consent to hold the office as independent director. Sudhakar.
Yeah, this also I have covered it. When you are going for a second term, it is as good as appointment itself. So for this, the consent, the disclosures of interest, everything is to be taken once again.
And is it necessary for that independent the candidate to be independent director, that his name should be mentioned into a database?
Yeah, it is of course there, because see that whenever those are the prerequisites, that his name is to be there in the database. He has to clear the proficiency test, and not only that. See, the peculiarity of independent director is not only at the time of appointment he is to be independent. At any point of time, 24/7, he should establish his independence whenever it is questioned. The moment his independence got compromised for any reason, he has to immediately inform the company and he has to step down from the independent directorship.
Yeah, just to add what Sudhakar said. So the shareholders have approved an independent director on the fact that he is an independent director and is not associated with the company, right? So if there is any compromise on the independence, then he has to immediately vacate the office.
Yeah, I'll also add one more perspective to this. That is that in law, when it comes to a second term, of course the consent is required, because in law the term appointment has been defined to include reappointment. So all the procedural aspects which are associated with the appointment have to be replicated in the case of a reappointment.
Sudhakar, just adding to your point, when we are saying that later on a person an existing independent director catches with some disqualification. So the one condition is that he should not have the sitting fees or the remuneration which is earning from the company should not exceed 25% of his annual income. Right. So let's say,
in fact, not only about the monetary thing, there are several things. The parameters, whatever are there under 149(6), as well as of the listing regulations, any of the parameters got affected and that independent director lost his independence, he should vacate his office.
So let's say he lost his other incomes and the remuneration from the company itself goes more than 25%. Then it is the duty of the independent director to inform that my income from your company is exceeding 25%. I should not be eligible to continue with the independent director. Is it that?
No, Praveen, let me add here, there is a clarification that it should 25% of total income, right?
Yes.
It's total income. It's not necessarily 25% of income from that particular company. And secondly, to add to what Sudhakar said, all the attributes of independence under 149(6), these are all conditions which are mutually exclusive. So if you don't satisfy one condition, you don't satisfy the other also.
Kalidaji, I'll reiterate my question once again. Let's say one independent director is there. His total earning is 10 lakhs. He is earning 2.5 lakhs from that particular company as an fees or commission. Let's say his other income, he has lost his other income of 2.5 lakhs. Now his total income goes remain to 7.5 lakhs only. In that case, the 2.5 lakh which is getting from the company is exceeding 25% of income. Whether he should inform to the company that yes, now your income from your company is more than 25% of my total income, so I'm not eligible to be an independent director and should.
Absolutely, he should. The benchmark is that if you say that that's the only income he's getting in his life, then of course, if his income exceeds 25% from the company, then he loses his qualification as an independent director.
Correct. Okay. Manikanta, my question to you is whether independent director shall be included in the total number of director for the purpose of section 152, 6 and 7.
No, I think Sudhakar already deliberated on this, right? So if there is a retirement of rotation, which you're speaking about, the independent directors is out of the purview, right? So therefore, the board has to be constituted in a manner which the 2/3 has to be retiring every year. Out of the 2/3, 1/3 has to be retiring every year. But the lot itself of 2/3 has to be outside of independent directors.
Correct. Sudhakarji, the question is continuation to your earlier discussion when we are talking that the new independent director's appointment or the reappointments of that same independent director resolution has to be passed before his existing tenure expires. So are we talking about the board resolution only or the shareholder resolution has also to be passed?
So first term appointment, as I mentioned to you, board can appoint him as an alternate director, designated as an independent director, subject to the approval of shareholders. So at the next general meeting, you have to take the approval of the shareholders. However, as I clarified that, the tenure will start from the date of the board meeting, not of the shareholders meeting. Now, second term of appointment is concerned. That is only the prerequisite is on passing a special resolution by the company. So that special resolution should be there before the first term expires. So the board has to recommend to the shareholders. Board cannot appoint. Board has to recommend to the shareholders for his reappointment as an independent director for a second term of 5 years. That's how it has to be.
So board is recommending, I think that should be enough because they have 3 months time to get it approved from the shareholders. So that can be done within 3 months of time.
Yeah.
And even if his tenure is expiring, that doesn't mean he is no more independent. He's continue to be an independent till the moment the 3 months expires or shareholder does not approve the appointment. Correct?
You have to say that before the first term expires, you have to have the shareholders' approval in your hands. Whether it is whether you convene a general meeting or you do it by way of a postal ballot or whatever you do it, it is up to you. But as a company secretary, you have to be very, very careful because one of the company secretaries about a few months before asked me a question that he has put up a note to his management. The management has taken their sweet time before giving the clearance for reappointment of that independent director. In the meantime, his term got expired. After expiration of his first term, he got the clearance from the management who can go ahead and appoint him. So he cannot be appointed for the second term in such case. So it is a responsibility of the company secretary. If your independent director's tenure is getting expired in the next year, advisable to get him appointed before, this AGM or any general meeting taking place before his expiry of the first term.
Yeah, just one important point to add. Whenever the reappointment happens, it has to be based on the performance evaluation.
Correct.
So therefore, you can't even appoint very well in advance. You can't make an appointment 1 year in advance, right? So, but it has to be very close to the term whenever it is ending. And it has to be based on the performance evaluation. It's only then the NRC can be proposing recommending to the board and then the board to the shareholders.
Yeah. See, to give an example, Praveen, suppose, say, for example, my AGM is there in the month of September, and this independent director's tenure is getting expired in the month of May, succeeding year. So before May, I am not in a position to hold a general meeting, or my AGM will not take place. In such case, it is advisable for you to take the approval in this AGM itself. Okay.
Praveen, I just wanted to add to what Sudhakar and Mani had on this. Now, I entirely agree with both of them on this. But where it comes to this retirement of independent director not being liable to retire by rotation, I'll give one perspective which a lot of people are facing, particularly because of the conception in the law that a nominee director is not an independent director. So if he's not an independent director, he's liable to retire by rotation. And as you know, the financial institutions have the right to nominate their persons on the board under a strength of a specific legislation, under the LIC Act, or for that matter, the UTI Act under Section 26. The Unit Trust of India has a right to appoint a nominee, and the nominee will survive as per the whims and fancies of the appointing institution. So therefore, this comes in the way of retiring, considering nominee directors as liable to retire by rotation, because of the fact that these are special legislation which will actually override the provisions of the Act. But notwithstanding, I agree that you'll have to consider them as liable to retire, and you'll have to explain to the institution that this is only a technical requirement which you are complying with. Otherwise, actually, you have no right to ask him to retire.
Sudhakar ji, this continuation to your question, let's say the NRC has approved the appointment as an additional director only. Later, board says ki yes, now we want to appoint him as an independent director, inverted commas. Is it okay that while approving, the board says ki yes, now we'll appoint him? Or as in second part of the question, let's say board is appointing him plain as an additional director only. But later on, while going to the shareholders for approval, they come out with a different mind. Okay, we'll appoint him as an independent director and we'll place the request before the shareholders to approve him as an independent director. Is it okay? Is it doable?
It is the responsibility of the Nomination and Remuneration Committee to recommend. They cannot appoint, they can only recommend to the board. If they are recommending to the board simpliciter director, board has to appoint him as an additional director, but simpliciter director only. If NRC, if that company wants to appoint independent director, then it is the responsibility of NRC to examine the parameters, whether the incumbent is satisfying all those parameters or not. So board cannot on its own appoint a person whom the NRC has recommended to be a director, and at the time of board meeting they said no, we will designate him as an independent director also. No, the board cannot do that. They should not do that, rather, because the parameters to be examined. And similarly, see that if you see that 149, if I am not wrong, it auto says that it is the responsibility of the company to also ensure the what's called the ethics, that integrity of the person to be appointed as an independent director, apart from all the qualified parameters. So it is not a simple thing across the table. You will take a decision. Needs a lot of homework for that. And a lot of due diligence also is to be done about the independent director who is going to be appointed or recommended.
Just to add, Praveen, on that, so now I think both Kalidas and Sudhakar had mentioned there is a requirement for an NRC to see, first of all, why are you appointing a director as an independent director? Right. So first of all, when the NRC is looking out, they have to see the balance of skills. Whether is there a requirement, is there a skill gap within the existing board, has to be first ascertained, and then you have to see whether a person is satisfying the independence or not. And the second part is the incumbent should also give a declaration saying that he's satisfying the independence test or not. Right? So without all this, if there is a decision which has been, or a recommendation which has happened to an NRC and then going to the board taking another view, it looks a little bit of a lack in the process.
Correct. My question is to Kalidas. This is regarding filing of e-forms. Is it necessary to file the DRHP for reappointment of independent director for the second term immediately after the expiry of his term, if the shareholders' approval for the second term has already been accorded by the special resolution?
Well, you see,
of the first term.
Yeah, to my mind, this is not required because it's only a continuation. But, leaving aside the requirement of a particular form to be filed, given the fact that this is a fresh term, I mean, although the MCA portal will not allow, there is, to my mind, having articulated on the concept of reappointment, to my mind, it is actually, although it's a continuum of the fresh appointment, it's a fresh appointment in a sense that reappointment includes appointment. So there is a case for filing it, but if the portal does not permit, to my mind, there is no requirement for filing the 12. I think it does not allow. So if I'm not very familiar with the filing of the form, but to my mind, it does not allow the filing of a form for a reappointment. If
you are correct, form will not be allowed. DR12 is not allowed.
Yeah.
The system will not allow you. So, Dakar, my question is to again in continuation to your earlier discussion we had regarding the disqualification attained by independent director during the tenure. Let's say if the independent director has attained some disqualification and he or she has not disclosed it to the board, and it comes to the knowledge of the board. So whether the board or the company secretary could initiate or they can request removal or cessation of the office of the independent director through the board or to the chairman, or company can initiate itself. Who's responsible for this, board or company secretary or the independent?
See, first and foremost thing is, it is a responsibility of the independent director to inform the company. The moment he comes to know that his independence got affected or compromised, it is his responsibility, because sometimes it may so happen by the time it comes to the knowledge of the company secretary or the company, it may take some time. If this independent director is keeping quiet as if he doesn't know anything, and the moment the company comes to know, it will be automatic cessation. There is no question of any removal and other things, because his independent got compromised. He is disqualified to be as an independent director. So his position got seized. There is no question of any removal. And whatever the penal provisions are there, he will get attracted if he is keeping quiet, or if he is what's called it is virtually a kind of cheating or committing a misrepresentation to the company, to the company.
So the moment he is disqualified to be, or whether his name is removed from the independent director's data bank, or he failed to pay the fees, anything is there, he is supposed to be disqualified and immediate removal is there.
As far as the data bank is concerned, his proficiency test is concerned, this is the responsibility of the company secretary also. He should keep a watch on that thing. He should take declarations on every year that by independent director has got his ship renewed and all those things. By merely taking a confirmation, affirmation is also not sufficient. The company secretary should also check that whether that gentleman is qualified or not qualified, proficiency test is passed or not passed. Similarly, in the database, his name is there or not there. Okay, so this is the both ends. He has to take a declaration also, and he should do the due diligence also. If it doesn't happen, obviously he ceases to be an independent director.
Correct. My question to you, Manikanta, you being company secretary of a very professionally managed company, but what about the companies where these are promoter managed? And what can be done when the independent directors' views or suggestions are not being taken care by the management? Specifically, when we are talking about some promoter managed company where director tends to agree to everything which has been said by the promoters. So, what are the remedies available?
I think it's a practical approach, right? So, first of all, as Kalidas was saying, so independence is a state of mind. First of all, you have to come from that point of view and provide your candid response or candid replies. So in the process, you may not tend to agree with the promoters or even with the management for that fact. So therefore, it is an art of how you communicate your point of view to the promoters or whoever is the dissenting directors. And also, the law gives you an opportunity, especially for the independent directors, to record their dissent in the minutes. So that is one important thing which probably they can use it as a tool to express their dissent recorded in the minutes. And when it becomes, I think it becomes very handy in case if you want to defend it at a later point of time. Right. So therefore, there is enough measures provided under the Act. Having said that, I think it is more of an art than to do anything.
But it continues to you whether the finalizing of minutes is the rights or the authorities of chairman. What will happen if the dissent is not properly recorded? Number two, let's say dissent is recorded, whether the director is absolved from the duties of such guilty or act at later date just because this dissent is recorded.
No, so I think you have a very limited choices there, right? So if you are able to get your point noted, then you're discharging your duties correctly. And I think there is also a part which the management or the board chairman and the company secretary is doing. See, ultimately the minutes are only the reflection of what the deliberation happened in the boardroom, right? So if you are not capturing that correctly, then it's not an accurate way of recording the minutes. So therefore, independent director can also use other means of reporting or probably resigning, right? So when he resigns for lack of all this cooperation, or I would not say cooperation, if lack of all this transparent way of recording the minutes, etc., then obviously he can resign from the position. And when there is a requirement to list the reasons of why you have resigned from the company, and that also has to be submitted to the stock exchanges, right? So this is a mechanism where you can actually list out things of what exactly had a problem. And in fact, now under the company law committee report, which has come out very recently, has actually given a good way where the KMPs or the directors, in case if they have a problem of in the company, they can actually write as a part of their resignation letter and also submit to the company ROC, Ministry of Corporate Affairs. You can submit it as part of the resignation letter. If the company is not filing the form DIR12, then there is a capability of filing from the independent directors or the directors side as well.
I just add one more perspective to what Mani said. In fact, 149.12 gives the gateway to the independent director that if his dissent is, if he has voiced his dissent, then that's a defense which is available to him, and he cannot be accused of being a part of the process of commission or omission in case of any action which is precipitory action which is taken by the department. So one way of recording one way of absolving yourself from liability is to ensure that the dissent is recorded and recorded properly.
Praveen, I want to add one more thing also for this is that this is where Secretarial Standard 1 comes into the picture as far as the finalization of minutes are concerned. It is not the chairman's fancy to finalize the minutes according to his whims and fancies. If the directors are giving their observations, if the directors want something of their saying to be recorded in the minutes, unless until it is derogatory or defamatory to other directors or to the company as such, the chairman has to record those things. And as far as the dissent is concerned, if I am not saying, it is short of saying that SS1 says the chairman is duty bound to record the dissent is concerned. And similarly, at the same point of time, let me also say that anti-promoter is not independence. Independence does not mean you have to be always anti-promoter. That is one thing independent directors has to remember. Whatever chairman says or whatever the promoter, if he is the chairman, if you are going accordingly, that doesn't mean you are not what's called as you are not an independent director.
And this
are not an opposition party.
Yeah.
So the dissent can be for any part of that particular agenda, or it has to be for the complete agenda at once?
No, not necessary. Particular resolution. See, let me tell you one more thing also. In fact, SS1 also gives the liberty to the person who has not attended the meeting. But still, when the draft minutes comes to him, he wants to express his dissent for a particular decision taken by the company. He can express his dissent. Chairman cannot say, look, boss, you have not attended the meeting. How the hell are you concerned with this? No, he cannot say that. Moreover, if the director is keeping quiet, whether independent or non-independent, if the director, when he received the draft minutes, he is keeping quiet, he will be deemed to be a part of the decision making, and he will be held liable, God forbids, if anything goes wrong. As Mr. Kalidas has mentioned, that point of time, 149.12 will not come to his rescue.
And that will not impact the decision taken by the properly constituted quorum during that meeting. But only dissent can be recorded into the minutes.
Yes, correct.
Thank you. The question is, if an independent director asks for certain information from the management and he is not able to receive that information, or it's not being shared to him in a transparent manner. So what remedies he do have, he should approach to the board or the company secretary, or whether he can make liable anyone, and what resources company secretary have, because if management does not wanted to provide, let's say CFO or CEO is not willing to give that information, then how we can have the information from the company and provide it to the independent directors. So what are the remedies to the independent directors as well as the company secretaries? Sudhakar ji.
See, the first connect to the independent directors as far as the company is concerned, it is always the company secretary. So through him, he has to communicate with others. Not necessarily he has to go through him only, but that is the proper way of approaching others. Suppose the company secretary is not able to get him the information, he may approach either the CFO or the CEO or whoever is there, but he's not getting the information. In case the company is having a lead independent director, and he is an independent director, he can always approach the lead independent director. Otherwise, he can directly approach the chairman of the board and inform him that he is not getting the information, whatever he is doing this thing. That's how he has to do it. This is the process, in fact.
Manikanta, I also wanted to know your view on this, because this is something a practical issues, and you being into big corporate, you must be having some guidance on this.
No, fortunately, we don't have these problems.
Yours is a well-managed and a well-professionally qualified board, but yes, somewhere if you can guide on this being...
No, I think Sudhakar made a very good point. So I think the first point of contact is the company secretary. And of course, they have as an independent director, you have the resources at your disposal, right? So you can call upon the entire management team, either the CEO or the CFO or the general counsel, or whoever is the one level below the board. They can approach all of them. In case if that still is not working, then the proper authority is logically the lead independent director, and then after that he is the chairman, and collectively as a board as well, right? So board, in fact, that's a good point probably to bring it up in the board discussion, to say that these are some of the things which has been not provided for discharging their own obligations as part of the board member. And again, it can go back to your recording of the minutes, so that there is a clear way of articulating and there is a clear record to say that this has been asked for but was not provided.
In fact, one thing, Praveen, that you were mentioning, I think 2 times I heard, Manikanta, you are working for a professionally managed company. To my knowledge, every company is a professionally managed company, not only Manikanta's company, all the companies, number one. Number two, let me also tell you that there are several closely held companies. In fact, I have worked in my formative years with closely held companies. Absolutely impeccable compliances, governance provisions, they do comply with. I think to my knowledge, very minuscule companies are there which are fly-by-night operators. They are operating those companies. Otherwise, to a large extent, Indian promoter is always compliant.
Thank you. You just noted, but the meaning is that there are certain corporate houses into our country wherein people just wait for their annual report to come down, and based on that, this is the final decision or this is final interpretation, and yes, we can adopt this, because they would have worked a lot of on this point, and they would have done a lot of research. So this could be something which is acceptable into the industry and the corporates and the regulators, so we can adopt it. So that could be the intention. Yes, but Kalidas, my question to you on this continuation of the same discussion topic we are discussing, what is the remedy company secretary and employment do have with him in this kind of scenario? Is it okay, or is it the only remedy before him to express before the independent director, this is the what I do have, maximize to present it before you in your platter. I don't have anything more than this. If you want something more, contact to my CFO or CEO. Sir, unmute.
You see, a company secretary's role is not necessarily a role which is built by law. The company secretary's perception of a company secretary by the management is also extremely important. So if the management perceives the company secretary as an important resource, then even if he doesn't have the kind of gray hair that I have, a person holding the position of company secretary can command respect. So in this situation, if the independent director approaches the company secretary and says that, look, I'm not getting the information that I'm seeking to have, in that case, the right thing for him is to flag it off. Normally, companies do not allow the CS to operate under a CFO. That's not, to my mind, a right practice. But some companies do. In that case, you refer the matter to the CFO. Or alternatively, the right thing is for you to refer the matter to the managing director and say that this is what has been the complaint received by him. And that's the way to go about it. And final refuge is the chairman. And in case nothing happens, then probably too bad for the company secretary, he must seek greener pastures.
Yes, Sudhakarji, you wanted to add something on this?
See, here one thing I want to tell the participants is that the company secretary is not a postman here. He cannot simply say the independent director asked him for some financials. He went to the CFO or CFO said, I won't give you. And he is coming back and said, like, look, he's not giving, what can I do? It is not so. Company secretary should be having the maturity. He should be able to convince the CFO that this information is being asked for the independent director and we have to provide him that information. And even legally also, the company secretary is under an obligation. He is the facilitator between the board as well as the management is concerned. So here, the role of the company secretary is very crucial. That's why he should be knowledgeable, he should be experienced, and he should be matured enough also. He cannot simply express his inability. The moment he expresses his inability before the independent directors, he will lose his credibility as well as the credibility of the management and the company also.
Perfect thing, I think.
I mean, I just wanted to add.
Yeah, please, Manikant.
There is an interesting element from the board evaluation perspective also, where it asks for how the information flow is happening from the management to the board, right? So this is one of the important area. Probably the independent director, whoever is not getting this kind of an information, probably they can give a feedback, right? So this is one of the mechanisms which can be used.
Praveen, I'll butt in. There is a question in the WhatsApp group which is specific to me, which I would like to answer. Somebody has said that there is no provision in the law that provides for payment of sitting fees to a director for attending general meeting. Is my understanding correct that Kalidas mentioned such fees can be paid? I am unable to understand, in the absence of legal provision, how fees can be paid. Now, I wish to answer this. I said that, you see, you look at section 197(5), it says, I'll read out that specific provision, if you like, because I think it's an important matter, because I have kind of, stirred the hornet's nest, as it were, by raising this question. But if you look at 197(5), 1 minute, I will read out the language specifically. 1 second, please. Yeah, 197(5), 1 minute. It talks about, 197(5) says a director may receive remuneration by way of fees for attending meetings of the board or committee thereof, or for any other purpose whatsoever as may be decided by the board. Now, the section itself is giving an opportunity to the board. When in law, when the expression, or there is a difference between the usage of a proposition and or suggests an alternative and is a cumulation. So therefore, here, when the section itself gives the board the authority to decide on payment of fees for any purpose whatsoever as may be decided by the board, and I pointed out that Rule 4 is saying that it shall be restricted to 1 lakh for meetings of the board and committee. Now, the rule cannot dictate the act. The subsection will prevail in the case of inconsistency, and therefore, to my mind, there is a possibility. Admittedly, it's a controversial view that you may want to take, but the fact of the matter is that the independent director is investing his time in attending an annual general meeting. So logically, there is one way of doing it, but that's a subterfuge which I would not like to adopt. What companies do is that on the date of the AGM, they have a board meeting. so that he gets paid for attending the board meeting. That's not the way, to my mind, to approach. You have to take the bull by the horns. And when the section is allowing you, 197.5 says for any other purpose, the board can say that the independent directors shall be paid sitting fees because there is a responsibility they have to attend the meeting. Board can pass a resolution that we shall pay sitting fees for attending independent meeting of the general meeting. So 197.5 will prevail over Rule 4. This is what I wanted to clarify.
Yes, Sudhakar, you wanted.
Yeah, I absolutely agree with Mr. Kalidas on this particular thing. Legally, it is absolute. There is no restriction at all, and it is the entirely discretion of the board. But a director cannot take it as if it is his right to demand from sitting fees for the attending the general meeting from the company. It is entirely discretion of the board.
Correct.
But governance point of view, there may be an issue. Shareholders may say that, look, we are also coming. We are part owners of the company. We are attending the meeting. What big the directors are doing. So that's why what happened is there may be a governance issue, but there is no legal issue as well.
In fact, this point is deliberated in the guidance note.
Yes, correct.
Thank you. My question is to Sudhakar. Can an independent director ask for additional independent director insurance coverage beyond the regular D&O policy into the company that is applicable for other board of directors?
It is the discretion again of the board as far as the D&O policy is concerned. What listing regulation says, the top 1,000 listed companies based on the cap, the market cap, they have to provide that D&O policy. As far as the how much is the amount, how much is the premium, etc., etc., that is left to the company only. However, if an independent director expresses his concern, and at that point of time, the company has to address his concern. The way he is getting insulated or his risk is covered.
Kalidas ji, my question to you, before appointing as a director on the board of a company, whether the candidate can speak in person with the existing auditors or solicitors of the company as a part of due diligence in strict confidence?
Well, yeah, to my mind, because you see, independent director's appointment is not, let us understand, at the end of the day, even the law is not providing for a very huge compensation. It's not a bed of roses. So therefore, when I'm sought to be appointed as an independent director, given the responsibilities, now I have to clear a related party transaction also. Given the responsibilities, it is perfectly within my duties to exercise a due diligence, much the same way as a company will make a due diligence over an acquisition. Similarly, I shall look at the several aspects, the antecedents of the directors, how well they are where it comes to compliance with law, whether there is any default, ROC matters, SEBI, whether there is any stricture from the stock exchange and things like that. Therefore, he cannot seek an official request. He cannot make an official request with the auditor and ask for his comfort. But by all means, in strictest confidence, like, supposing it's very typical, if you are approached for a job opportunity, don't you check with a lot of people, including probably the auditors of the company? So I think there's nothing wrong at all if I make a due diligence that way, but I can't do it officially.
Okay, but in extension to this, I just wanted to ask an additional thing, that whether when the name of the independent directors is posted on the portal, that these are the people available as an independent director, and we may choose any of them to whom we know best as an independence is concerned. Whether the name of the companies are also mentioned somewhere into any portal where compliance and have been ranked, and these companies have been ranked as the top 10 or top 100 ranking company, so that a person who is willing to be appointed as independent director can choose either of these companies. Yes, I should go with this company. Kalidas ji, I'll come to you, Manikanda.
Yeah, no, you see, it's like this. Where it comes to my perception about a company, indeed, I will go by the rank of the company. And now, of course, there is this requirement that I shall only appoint somebody who's enrolled in the portal. So then I would like to know, firstly, what is the ranking of the company? And I will only go for a company like if somebody tells me that, yeah, you are invited to join the Infosys board. Again, not taking anything from what Sudhakar said about professionalism. Now, because of the perception that the public has about Infosys, and my own perception, because it's one of the few companies that comes out with audited quarterly results. So therefore, I will say that yes, I will opt for it. So I mean, it's like that. If you are getting a job opportunity, then obviously I will go for that company where there is greatest transparency.
Yes, Manikanta, you wanted to add something on this.
No, I had a little bit of a different view. See, this is not a job portal. You are not putting the candidates out in the public, and you are also not saying that these are the number.
Yeah, exactly. Yes,
it is the requirement of the independent directors. It is actually the other way around. First of all, if you see the requirements now, as per the latest listing regulation, it casts so much of responsibilities on the NRC. Now, why do you need an independent director on your board? Where are your skill gaps? What is that expectation you have from an incumbent director? Right? Those are some of the real tough questions which has to be answered. And of course, succession planning, diversity, or some of the other things which has to be borne in mind before you look out for a candidate, right? So only if all those parameters have met, then the next step of appointing or inducting on somebody on your board happens. Now, just because there is a enrollment on the directors database, it doesn't happen automatically, or it is not a job portal, is what I would like to say.
Yeah, correct.
Right. My question to Sudhakar, this is something very close to you, I believe. If I am in the board of a company as a part of selection committee, then what due diligence do I need to take care before having one member on the board as an independent director?
See, first and foremost thing I have to say is legally whether he is qualified or not, because otherwise, whatever he is qualified, I cannot appoint him. First and foremost thing is I have to ensure that all the legal parameters have been taken care. Once that is in place, I will see his conduct and character. That is more important for me when I am selecting. If I have a selection committee part, I will see his conduct and character. He may be having tons of experience. He may be having tons of maturity. But what I will do with that, unless until he got a conduct and character. So I will definitely conduct a due diligence as far as his conduct, character, ethics, and other things are concerned. Once these are in place, the next step is his maturity. How he is, in which all companies he is a director, if at all he is there, or what is his corporate experience, what are his achievements, and what are his milestones in his corporate life, if any kind of black marks are there in his record. These are all the things what I have to see. At the same point of time, his temperament, sometimes it may so happen, all the things are in place, but he is a very short-tempered person. He is not a team person. At the end of the day, I have to have a person in my boardroom who will gel with the board. Otherwise, what will happen is that he will say always, as Mr. Kalidas has mentioned, my way or highway. You cannot, that he will become a burden to you. Same, I am sure that every one of us, whenever we select an employee, more or less, these are the parameters on which we select. To a large extent, the same parameters, I will extend it to a director, but in a more intensive way.
So to check the income criteria, can I ask him to submit the copy of his last income tax return?
How I'm concerned with his monetary things. I'm not concerned with that.
You need to check whether the remuneration which I am giving to him shall not exceed 25% of his total income.
I'll answer this. This. I don't expect. I think the company is not expected to be an auditor. Yeah. See, independence is something. It is a self-regulatory law. When I declare that I'm independent, then there is an assumption that I have satisfied all the criteria. So if you are appointing somebody as an independent director, which is an exalted position, then you will have to accept him on face value. The law doesn't tell you that you must investigate into his tax return and things like that. As Sudhakar rightly said, you know about his credentials in the market. You look at the perception of people that people have about him. That's it. And I don't think the company secretary is expected to be an auditor to check the veracity of the tax return and calculate what is the income that he will get from the company and say that he's going to exceed 25%. No, I don't think that those are expected of you. You are not a bloodhound. The company secretary is not a bloodhound. Neither is he's of course a watchdog with a pinch of salt, but I don't think he's expected to be a bloodhound. Praveen, I have to take one last question, then I'll have to break away. As I told you, there's an issue I have. So I'll have to forgive me.
Only 1 minute, 1.5 minutes I will take, Praveen, that what Mr. Kalidas has said, that if I give an example, when you are appointing a company secretary or a chartered accountant in your organization, are you cross-checking his membership with the institute? Are you getting his certificate verified by somebody who got that thing and forensic person or something like that? The answer is no. The trust is very important.
Correct.
When you are appointing an independent director or a senior executive of the company, the trust is very, very important.
No, also there is an undertaking. When you submit any form, there is an undertaking provided as part of the form to the company, right? So
later that would come to a message statement from your part. So
exactly.
I
just want to add to the previous point, when you are part of the selection committee, what will you look at it, right? So one big thing which I look at it, or most of the companies will look at it, is actually of what value addition can make.
Yes.
What the incumbent can make a big value addition. So I think we spoke about, they are not independent directors are not an opposition party, right? So therefore, in a way, how will you navigate the whole thing, take your company to the next level, is something an incumbent should be thinking and contributing to it. So that's what I actually look at it.
Absolutely right.
Thank you.
Praveen, if you'll excuse me, I can take one more question and then I'll have to take leave from this forum.
You have chosen your own question, or should I come through?
No, you give me a question, I'll answer.
I'll come with a small question. Very simple thing is that whether independent director shall be liable for default in repayment of bank loans.
The answer here is that, independent director is not in fact, if you look at the decisions on the liabilities of independent directors, 149(12) clearly firstly says that if he has, he's not somebody who is in the day-to-day management. Therefore, if he is part of a committee which has, approved a bank loan, it is not as if, it's not that he is expected to express his dissent. There are more people, there are people that are more intimately connected with him, with the borrower, who can make a more perceptive assessment about the credentials of the person. So to my mind, merely because he is a part of the decision-making process and merely because he has not given his dissent, it does not mean that. And there is also this principle of alter ego, which the Supreme Court has spoken, where it comes to attaching vicarious liability to an independent director. If you read the decision of the Supreme Court in Sunil Mittal versus Bharti Airtel, the court has said that you can only haul up people that have positions of authority. Now, obviously, an independent director does not have a position of authority which is similar to that of a managing director. So if he is merely an independent director and if the loan has gone fud, then are you tell me the answer lies in the fact that have the independent directors of Gitanjali Gems been hauled up because of all the frauds, or for that matter the independent directors of Kingfisher, are they behind the bars because the loans have gone? So the answer is obviously no. I mean, and you don't expect every time that the dissent should be recorded, right? Thank you very much. I'm afraid I have to make a departure from the...
Hold for a moment. There's one question which really I want to have your inputs, and it's really touching for me. When we are talking about the independent directors meeting and company secretary, when we are talking about the KMPs, that company secretary, CFO and CEO. So the CEO and CFO are generally called as an insider person, management person, but company secretary is asked as an administrative person who has to bridge the gap between the regulators and the board, the shareholders and the so independent are more comfortable with the company secretary as an administrative position. Whether the company secretary should not be allowed to participate into the independent directors meeting when he is privy to the very price sensitive information and considered to be most confidential person into the corporate. I just wanted your view on that.
I'll tell you this. You see, again, this depends on the perception of the company. If you are having a board which is very, very articulate, very, very forthright, the company secretary is the first one to be involved in these matters. In fact, the board will not allow the CFO to come in on the independent, because the decisions that the independent directors are taking are entirely non-financial here. Okay, so it is a company secretary who should be the first. He's the linchpin. He's the bridge between the board and the management. So therefore, I mean, again, it depends on that. There are some companies, sadly, the company secretary does not even attend a board meeting. Now, that you can't do anything about the mindset of a management. But at the same time, there are companies which say that the company secretary is the first person. He's like the, the Ganesha. He is the one who starts and ends the proceedings. So therefore, it's entirely perception based. Look, there are companies, ACC, for instance, I bring the example of ACC. Why? Because ACC had its audit committee in the year 1984. Nobody told you to have an audit committee at that point in time. ACC had its nomination committee in 1989. Nobody wanted, but then that was because of the forefathers like Nani Palkiwala. So it's the perception based. If you are aware and conscious of the role of the company secretary, by all means, you should involve him in matters such as the independent directors meeting. Thank you very much. I have to take leave. I'm sorry, my apologies for... but I think we have covered substantially most of the questions. And sorry, because of there is a demand on my time, I have to leave for somewhere else at 6:30. And thank you very much. I've enjoyed myself, and I'm thankful to the Institute for giving me. And there are certain views which I have expressed which are not in consonance with the views of the Institute. I may be excused because, as I said in the beginning, these are my personal views, right? Thanks very much. Namaskar.
Thank you for sparing up your time. Sudhakar sir, I just wanted to have your input on this, whether KMP should be allowed into the independent directors meeting.
The question is, Praveen, it is the responsibility of the company secretary to gain importance in the company, to gain the confidence of the board. The moment you gain the confidence of the board, obviously, they will not even start the board meeting. They will not even think about the board meeting without the company secretary. Let me say one thing very well. The promoters as well as the directors, they know their legal responsibilities and accountabilities. Lot of companies are giving importance to the company secretary, especially post Companies Act 2013. Our profession got a significant amount of importance. Now it is up to us. In fact, several forums I have mentioned about this thing. If you are in service, you are recognized as a key managerial person. If you are in practice, you have been rewarded with a secretarial audit. Now, it is up to us to rise to the occasion and to prove our mettle to the regulator. And at the same point of time, to the corporate and to the companies as well as to the managements. I always say that company secretary position is a person-driven. It is not a profession-driven as such. So, Institute has discharging its responsibility as far as the training and imparting the skill sets with a good syllabus, etc. things. At the same point of time, it is the responsibility of the professionals also to inculcate good habits as far as the professional is concerned and plan it very well in the formative years itself. So, whether the company secretary is to be called for the independent directors meeting, legally they are not under an obligation. Because what is the purpose of the independent directors meeting? The independent directors wants to share certain things as far as the management and promoters are concerned, as far as the executive directors are concerned, without any kind of inhibition, without any kind of insecurity. They should be able to call a spade. And after that, they may be identifying a person out of them who will be communicating their viewpoint to the chairman. And the chairman, without disclosing any identity of any person, he should be able to take corrective and remedial measures for that. Mani, you may add to that, whatever you.
No, I just wanted to add, also on the independent directors, the deliberations or the agenda, if you look at it, they also have to do a performance evaluation. of the entire board, including the chairman, right? So in some scenarios, you will not do that if there is a company secretary or any other key manager personnel, if they are sitting as part of the independent directors meeting. But having said that, I think there is a divergent practices which are happening across the industry. In certain companies, they are allowing the company secretaries to be part of the meeting. And also within those companies, sometimes they have been invited. Sometimes if it is purely performance evaluation or any kind of a sensitive matter which is getting discussed, maybe those meetings, the company secretaries are excused.
Sudhakar ji, my question to you is next: whether the spouse of independent director can hold shares in the listed company? If yes, to what extent and what disclosures are required?
There is, to my knowledge, there is no restriction as far as the holding the shares of spouse of independent director is concerned, but only thing is that disclosure requirements are there. That kind of restrictions and limits are there only for the auditors of the company. In fact, there is somebody has asked me recently a question that whether that is to be extended to the secretarial auditors also. Answer is no, because auditors, they are actually doing a kind of a different relationship as far as secretarial audit is concerned. They're having a different relationship. So whatever is applicable to the auditors, not necessarily everything will be applicable to the secretarial auditors.
One practical question, very small though. When an independent director is there, let's say appointment is there, whether company can bear the cost of taking din of that independent director?
No.
Or one more.
It's an individual.
They cannot. And two is, let's say when independent director is visiting to India, let's say if it's from another country, whether company can bear the cost of visa of that independent director also?
See, to a large extent,
of the attestation of documents also, which is a very basic task before getting the visa.
Unnecessarily, why you are indulging into all these kind of small things? According to me, whatever the obligations, personal obligations of the independent director is concerned. Say, for example, I will give an example to you, Praveen. You are an independent director of my company. You came from Delhi to Bombay. I am providing you transport from airport to my office back to the airport. On the second day, you want to go around for a sightseeing. Technically, I'm not supposed to provide you a car. Courtesy is a different thing. So whether to stretch to that level, you never know. If really you want to be an independent director and concerned, you have to have whatever your transparency levels are concerned, it should be a bit more. In fact, recently I was listening to some gentleman. He said that I think Mr. Balakrishnan, Professor Balakrishnan, who is from Pune, he was mentioning it at one place, that one co-panelist is there. She has been given a memento. In that memento, it was packed and wrapped in a particular what's called a gift paper. So she asked him, what would be the cost of this particular thing? Then he said, Madam, how it is concerned with? Then she said, look, as per my company's policy, I am not supposed to accept any kind of mementos or gifts beyond a particular value. Okay, so it is up to you how you are taking that thing. So, these are all, we are stretching a bit, whether his visa expenditure can be incurred by the company and all. According to me, if the independent directors, 1 year, 5 year or lifetime, whatever his thing is there, if at all the company wants to pay for the purpose of facilitating that, you may do it, but please recover it from the independent director. Company should not pay.
No, but let's say I'm just sorry, I'm stretching the question again. But if I am asking independent director to come India and attend my board meeting, he will say I am procuring visa because of your travel only. I am getting the document attestation because I need to visit India for your company's meeting. So you are supposed to pay my cost.
That's what I say. If he is exclusively coming for this particular purpose, you are reimbursing the expenditure. By all means, you can do it.
Okay, correct. One more question, Manikanta. I think we have already discussed on this, but just something different part of it. We have appointed an independent director for, let's say, 3 years, and at the end of 2 years only, we are saying no, I don't want to continue him for a period of 5 years at the first stage. So I am extending this for another 2 years. So whether this will be a second term or the extension of first term, to my knowledge, it's in second term.
No, so I did not get your question. Whether are you saying the first?
Let's say company has appointed a person as an independent director for a period of 3 years at a first stage. Now, before completing a period of 3 years, let's say in the second year itself, company wanted, no, I am happy with this independent director and I want to make him appointed for an entire period of 5 years. So now company is passing a resolution for continuation of his appointment for a period of 5 years. So this extension from 3 to 5 years, the second part of the 2 years part, this would amount to be second appointment or the extension of first appointment only.
It should be the second appointment. It should be the second tenure, but there is a little bit of nuances which you may want to look at it. First of all, if you are recommending at the end of the second year, that's not correct, right? So you have to. Why do you actually recommend or reappoint an independent director? If his performance has been satisfactory, you have to go back to the performance evaluation. You have to see whether he has performed correctly or not. Only after that assessment, you have to reappoint him or make a proposal for a reappointment. So just because you have appointed someone for 3 years or 4 years, at the end of 1 year, you realize that, okay, he's very good, he's adding value to your board, and you can't go and appoint him for the next 5 years after the tenure has completed of the first one. So I think it's not a correct approach.
Thank you. Mani, next question to you. This is something like when we are talking about the loopholes into the law, whether a person can be appointed as independent director of 20 private limited companies.
I think we have answered this many times. First of all, independence is a state of mind, right? So that is one point. And the second point is there is a proxy advisory firms who are watching of overboarding also. So I think you have to be a little bit careful of when you are doing these things. Of first of all, whether as an independent director can you spend so much of time of a listed entity and having all these 20 firms, whether will you be able to do it justice?
Private limited.
Whichever company, private limited also has a lot of time. It calls for a lot of bandwidth, right? So it's not a tick in the box. You have to definitely contribute to the company's growth, right? So it can't be just a tick in the box.
First and foremost thing, private limited companies need not appoint any independent directors. They are not under an obligation. Okay. If at all they want to appoint independent director, 20 private limited companies are appointing independent directors, and this gentleman as independent director, I really hats off to those 20 private limited companies. Let him be there with pleasure. There is absolutely legally there is no prohibition as such.
Looks to be theoretical question. Looks to be theoretical questions.
It's a theoretical, absolutely. So it is a doable thing. Let me put it this way. It is doable.
Thank you. One more question is that I am not a secretarial auditor of the company. I am just a practicing company secretary. Can I be an independent director of that company if I am providing some secretarial services? So I believe if monetary consideration is involved, I cannot.
So this is not up. If it is a BRD, a PCS, there is absolutely no issue. It is only for secretarial auditor. I think it is there. That restriction is there. PCS, there is no restriction as such. See, you can have as many permutations as combinations. Okay, can I like that? But better you read 149.6 and regulation 17 very clearly. Sorry, regulation 16 very clearly. Who can be an independent director and decide for yourself.
Whether the directors, Sudhakar, next question to you, directors appointed on the board of the company by the government or the PSUs, are they also required to pass the IICA test?
Proficiency test is to be passed by everybody.
Okay.
There is no exemption unless until he is exempted from that.
Any quorum prescribed for the independent directors meeting? I think minimum 2 is okay.
Nothing.
No, I think the general principle is to 1/3 of the strength of the committee. In this case, maybe the strength of the independent directors itself.
See, at least as far as the independent directors is concerned, it was though it is formal, but an informal meeting. Okay, no quorum requirements are applicable. But at least two people should be there. If it is to be called as an independent directors meeting, there should be the presence of two individuals should be there.
Okay. I think we have covered most of the questions. These are the basics only. Does the word ceasing to be independent director under 149.10 includes resignation also? Can independent director continue as non-executive director after the term of the first 5 years?
This I have mentioned in my presentation.
Correct. And whether an independent director holding company need to be independent of subsidiary also?
Yes.
That is, I think, for a material subsidiary isn't even requirement for the listed companies.
Correct. Yeah.
Correct. So, mandatory to appoint. There is no mandatory requirement for appointment of independent director from the database of the IICA only.
See,
No, everyone
it is not necessary. Sorry, Mani, please go ahead.
No, I was just saying that everybody has to have this their name registered on the directors database, right? So that is one important thing. But if someone is not there, you have identified them, they can always take a registration there and then make a prospect.
See, you don't need to pick up the name of the person from the database.
Yes.
The person whom you are picking up, his name can be registered there. After that, you will appoint him as the independent director.
Okay. So, my dear respected speakers, I think we have taken up all the questions which you have received. Some of the questions are repetitive in nature, and some are the basics which you have actually not attended. But rest, apart from this, we have taken all the questions. My sincere thanks to all the three speakers, Sudhakarji, Manikanta, and Kalidas in absentia for sparing of your valuable time. I believe we had a wonderful program there today, and thanks for your continuous contribution for the institute.
In fact, Praveen, in fact, you know that every moderator gives half a minute to the panelists to say the last and final word. Please give us.
So you are stretching it. Thank you. So just give me your last and final words. I'll start from Sudhakar on the topic or what you wanted to guide as a professional, as a senior member into employment who spent a huge amount of your professional life into the employment. And we have lots of young company secretaries, those who are going to be there into employment. So what final word of suggestions or guidance you wanted to give them? Please go ahead.
Yeah. My humble submission to all the participants is one thing. It is the excellent initiative of Institute of Company Secretaries to coming out with secretarial standards as well as guidance notes are concerned. The people who are there in the erstwhile secretarial standard board, now expert committee, for the last 3 days, whatever we are mentioning, on an average, every member is having an experience of not less than 25 to 30 years. And all these people are spending their time, each and every word, whatever is going into the guidance note or in the secretarial standards, it is weighed, measured, debated, discussed, and deliberated before we are finally putting it to that. Sometimes when I see that the awareness is not there among our fraternity, with all due regards, sorry my saying that, but the amount of awareness, what is supposed to be there, it is not there. People depend for their clarifications, for their doubts, more on the WhatsApp University than on the guidance notes. I always say that, why can't you see, for example, somebody asked in the WhatsApp, what is the section for corporate social responsibility? And somebody replied 134, and this fellow is profusely thanking him for that. For a section also, why you have to depend upon WhatsApp universities? Especially guidance note, bid regulation, CSR, and your related party transactions. The 4 guidance notes, according to me, they are the gems of ICSI. Very, what's called as, complex issues. All these 4 are concerned. Tomorrow, God forbids, if the regulator comes for inspection, these are the areas where he's going to examine. And as company secretaries, we should not fall behind in compliances because the penal provisions are very stringent. So my humble submission to each one of you is, please take these guidance notes seriously. Read right from the beginning to the end. At least one reading you give it, if not more. Thank you very much.
Manikanta, your last word, please.
No, I wanted to add what Sudhakar said. No, there is a lot of effort which goes behind preparing these guidance notes or the secretarial standards. It's not easy. As I was mentioning in the beginning, there are best of brains which are working, and if you see the guidance notes, it actually provides you the practical scenarios. There are questions which have been sourced from practical aspects, and then we are trying to address it. So it is the research and the amount of research which has gone back on each specific word is humongous. You can't imagine we had multiple conversations on a specific topic before we align and converge into a specific decision. So that's kind of a background work which is happening in putting together these guidance note or the secretarial standards. So what I would also like to say is, if in general, if you follow the secretarial standards and guidance note, I think your general compliance will actually increase. It actually is it enhances the corporate governance in any corporate is what I can vouch for. Therefore, I urge all the participants and the members to strictly follow the rules, follow these secretarial standards, and also make best use of the guidance note.
Thank you, Mani. I think wonderful thing which you have told, and that the same thing. I think the compliance is toughest thing, and the company secretary's position is there. And as regards celebration, yes, I have witnessed the same while 2 years when I was in SSB, and we were discussing on a single point, single sentence, comma, full stop for half an hour, 1 hour deliberations was there between Sudhakar, Kalidas, Satvinder Singh, Narayan Shankar. Lots of discussions were going on. So these were the issues, the best of the mind we were working actually there. Yes, I agree. And that is the input, output we have got as an independent directors, this guidance notice concerned. My sincere thanks to my colleague and professional friend, Narayan Shankarji, for giving so much of input for this webinar. Friends, we are having outstanding this 6th and 7th of May, the National Conference of Corporate CS, third Corporate CS Conference we are having into Kochi. So looking forward to see you all. I hope you must have got registered, because the maximum part of the registration has already been done, and the registration may stop in a day, might be today, tomorrow, that's it. As regards the program of series of this secretary standard is concerned, yes, we are going to see Sudhakar once again tomorrow on the next webinar we are having on the prevention of insider trading, along with Narayan Shankar and Pritesh Majumdar. So friends, be there ready to catch up the speakers on another important topic of insider trading. As regards the upcoming programs, yes, we are going to hold the National Conference of Practicing Company Secretaries there into Western region somewhere in the month of June. So friends, you all are requested to please guide your councils and institute on the topics and themes and sub-themes and the venue wherever you wanted to have. The best option will be chosen and the decisions will be taken by the council. But yes, your suggestions are always invited. My sincere thanks to you on successful completion of this part of the webinar, and I believe lots of learning we have got from the esteemed speakers on the independent directors guidance note and independent directors discussions. We have got lots of queries has been resolved. Some of will be unresolved. This is a part of the deliberations, and the interpretation always comes and it change. The law is that's such a specific and good thing that the answer change by passing of the time. So there cannot be a static answer, and the court will change the rulings, or otherwise it will NCLT, NCLAT, or the Supreme Court will change the ruling. So answer cannot be static, which we are saying right now. So this is again, the speakers have already confirmed it is their own personal view. We all three people are there from the corporate employment only. So yes, none of the companies can be responsible for our views, and it is our own personal view. Thank you so much to all the speakers once again, especially to Kalidas ji in absentia, Sudhakar ji and Manikanta for sparing of a valuable time for the benefit of members. And yes, we have participants have definitely got benefited out of this, and maximum good number of participants we have got out of this. Thank you so much once again on behalf of the institute. Many thanks for your sharing of your time. Thank you. Dhanyavad.
Thank you very much.
Thank you, Praveen. Thank you, Sudhakar.
Thank you, Mani. Bye. Thank you, Praveen.
Thank you.